Abolition. Today. Today.
The 13th Amendment clothed a radical departure in the nation's history in what a Boston newspaper called the well-settled language of a great historical document. But because of its very familiarity, the wording did not undergo necessary scrutiny. The prisoner exemption was almost never discussed in the press or at anti-slavery meetings and black conventions that urged ratification. Only a handful of critics sensed that it might cause problems. The language, the Abolitionist Journal, the Principia, charged as early as February 1864, changed the Constitution for the worse by appearing to acknowledge that slavery was allowable for adequate causes. Charles Sumner insisted that while the Northwest Ordinance performed an excellent work in its day, its wording was entirely inapplicable to our time, since it implied that men can be enslaved as a punishment for crime. Sumner wrote later that he had hoped to propose eliminating the clause regarding convicted criminals, but failed to act because his colleagues were anxious to get their dinner. I regret now my forbearance, he added. The exemption did not go unnoticed among white Southerners. In November 1865, former Confederate General John T. Morgan pointed out in a speech in Georgia that the 13th Amendment did not prevent states from enacting laws that enabled judicial authorities to consign to bondage blacks convicted of a crime. The Southern governments, established under Andrew Johnson's Reconstruction program, proceeded to enact a series of laws called the Black Codes to define and circumscribe the freedom that African Americans now enjoyed and make it clear, as Robert M. Patton, the new governor of Alabama, put it, that politically and socially ours is a white man's government. The Black Code of Mississippi, quickly followed by those of other states, gave blacks certain rights, such as having their marriages recognized in law, but also imposed all sorts of disabilities, including limiting their freedom of movement and barring them from following certain occupations, owning firearms, serving on juries, testifying in cases involving whites, or voting. Despite the 13th Amendment, involuntary black labor, justified by the criminal exemption, was central to these laws. They required all adult black men at the beginning of each year to sign a contract of labor to work for a white employer or face prosecution for vagrancy or other vaguely defined crimes. Those convicted would be fined and, if unable to pay, forced to labor for a white employer. Florida's code authorized the sale for up to a year of a free person who violated a labor contract. Apprenticeship laws authorized judges to provide planters with the unpaid labor of black children on the pretext that their parents were unable to support them. To be sure, vagrancy laws go back to the pre-modern era and were widely used throughout the country before the Civil War to punish able-bodied persons who appeared to be unwilling to work. But earlier vagrancy laws were not envisioned as the foundation for an entire labor system. Apprenticeship, too, had a venerable history, but the arrangements in the Black Codes bore little resemblance to traditional ones, whereby a youth learned a trade. Certainly, all this was not what former slaves and their northern allies considered free labor. Quote, "If carried into effect," a local black leader wrote to the president, "it will be virtually returning us to slavery again." "Where is the justice?" asked a black convention in Mississippi. "Where is the freedom?" Among other things, declared a New Haven newspaper, the Black Codes demonstrated the necessity of the second section of the 13th Amendment, authorizing further congressional action to protect the freedom blacks had so recently acquired. It was this sort of legislation the prominent North Carolina Unionist Daniel R. Goodloe later recalled, which caused the northern people, to believe that there was no sincere purpose on the part of Southern people to acquiesce in the freedom of the former slaves. The laws also, however, revealed the dangers inherent in the prisoner exception, as reports circulated in the North of blacks convicted of theft or vagrancy being sold for a term of years at public outcry. Disquiet rose in anti-slavery circles about the unfortunate phraseology of the amendment. A few members raised the issue in Congress. Cunning rebels, one congressman complained, were using the exception clause to reduce freed persons to slavery. God knows I wish we had that amendment before us at this time, said William Higbee, a radical Republican from California. We deliberated months, and yet we did not cover the whole ground. There is no good reason under heaven why a man for crime should be sold into slavery. In 1867, a national anti-slavery standard called for the passage of a new amendment eliminating the words "except" as a punishment for crime. That same year, John A. Casson of Iowa introduced a resolution clarifying the meaning of the exemption clause. No one, he declared, supposed when the amendment was ratified that in the very sentence abolishing slavery, they had also made provision for its survival under another form and through the actions of the courts. The amendment's true intent and meaning, his resolution declared, was to prohibit all forms of slavery and involuntary servitude except in direct execution of a criminal sentence under the immediate control of officers of the law, and not sale or other disposition into slavery. Casson's resolution passed the House by an overwhelming majority, 122 to 25, but did not come to a vote in the Senate. Many senators felt the Civil Rights Act of 1866, which among other things mandated racial equality in access to the courts and in judicial punishments, rendered the resolution unnecessary. Time would prove them wrong.
Abolition. Today.